All right, good morning. Okay. Good morning, ladies and gentlemen. This is Judge Jesse Law, and we are about to begin with the Fulton State All-Purpose Calendar. This is a calendar of misdemeanor criminal cases, which are still active and pending. And the defendants are in different parts of the Fulton County Rice Street facility. We're going to be addressing these cases on a one-on-one basis. I'll start with 4 South, since courtroom 2 still seems to be, we still need to get folks in courtroom 2. 4 South, who do we have, please?
Position number 18.
Thank you. All right, we have Mr. Orlando Xavier Poole, position number 18, and that's case number 21 CR 007589E. Mr. Poole, please remember that you have a right to remain silent. Anything you say in this virtual recorded proceeding, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Zachary Finling. Do you see him on the screen?
Yes, ma'am.
All right, great. Mr. Poole is accused of reckless conduct allegedly on September 30th, 2021. And if you give me a moment, please. Looking at these recommendations on position 18, and it appears that Mr. Finling, you want the case arraigned and address bond. Is that correct?
Yes, that is correct, Your Honor.
All right. And do you waive a reading of the accusation?
Yes, I do, Judge.
Thank you. Mr. Poole, I'm going to arraign your case. In other words, you're going to announce not guilty, if that is your understanding, and your case will be scheduled for trial. And after we've completed the arraignment, we're going to address your bond situation. So, Mr. Poole, you have been accused of 1 misdemeanor offense of reckless conduct. I'm not going to read the accusation pursuant to the waiver, but to inform you that upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, you will have the assistance of counsel, where the prosecutor would have the complete burden to prove the charge against you beyond a reasonable doubt. If the prosecutor succeeds, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty, Your Honor.
Thank you. Your case has been arraigned. We will address your bond. Mr. Finling, you may proceed.
Yes, Your Honor. Judge, Mr. Poole is 20 years old. He is born and raised in Atlanta. This is where all of his family lives as well. So he does have very strong community ties. He is not a threat to intimidate the witness, as he has no interest in further contact with Ms. Lett. And he's made very clear to me, I spent a lot of time with him yesterday, and he knows the positive trajectory that he wants his life to go. And he was very clear with that, and I could tell he was genuine. As previously stated, he is 20 years old. He has his entire life in front of him. And as we know, bond is not punitive, but rather to ensure his return to court. And he has made clear, once again, this trajectory he wants his life to go, that he undoubtedly will be back in court and plans to work and live with his mom once he's released. We are asking for a surety bond, Your Honor, and a surety bond not exceeding $2,000.
All right, thank you. Who's my pretrial officer? I'm sorry.
Good morning, Judge.
Good morning, Ms. Harrison. I'm so sorry. I was trying to find you on the multiple squares in front of me. I meant the shape of the Zoom. That's what I meant. Okay.
Blue.
Yes, Ms. Harrison, good morning. May I have his GCIC at least?
No prior history, Your Honor, and he was recommended at first appearance.
Thank you. Ms. Mitchell, you're the prosecutor for this particular case. So, I had set a $10,000 good bond back on December 16th. Any reconsiderations at this time?
Your Honor, no, we're going to request that the bond rec remain the same. As you're well aware, this is a case that involves a gun. He intimidated, actually 3 victims were involved. There was Shaliqua Lett, the aunt, Velvet Lett, the niece, and S. Lett, daughter of the niece. and the defendant was boyfriend to Miss Velvet Black. So they were all involved. They were all in Miss Shaliqualette's apartment when the defendant drove into the complex and fired 3 rounds before fleeing the scene. And the juvenile that was also involved was able to see that. They all witnessed it. So the state is concerned. Fulton County takes gun cases any cases involving guns seriously. So we're going to request that the bond rec remain the same.
All right. Mr. Findling, it was the egregious allegations that really fueled the decision for the bond. Have there been any contact with the alleged victims so far? Ms. Mitchell, Mr. Findling?
No.
Between the defendant and the victim?
Well, the allegations were that he went to this complex. Apparently there was some kind of altercation, verbal or physical, I'm not sure, but apparently the allegation is that he left the scene allegedly discharging a firearm in their presence, correct?
Correct. So it was stated in the case that they were Miss Shaliqualette and the defendant had a dispute over text, but once he was in the apartment complex, there was no interaction. Essentially, he came, fired the 3 rounds for intimidation and left.
All right,
But,
thank you.
Judge, are you asking if he's had contact since then? Sorry.
Yeah, he's had contact. The victims responded to this bond hearing.
Oh, I have
Assuming
not.
that victim advocates let the victims know that there was a bond hearing? No?
Checking
I've
your
not spoke with them, Your Honor.
Our victim advocate last contacted Ms. Shaliqualette December 16th.
Okay, the day of the initial appearance. Okay.
Yes, Your Honor.
Bond is going to be reduced to $3,500, and that's going to be a surety bond from the $10,000 good bond. This is a firearm involved case. I do not issue surety bonds unless there are extraordinary circumstances. So far, the circumstances have not changed from December 16 to the present time. But considering that this is his first offense, I will reduce it to a $3,500 good bond. Mr. Poole, I'm going to reduce it significantly, but you must keep in mind that the conditions of the bond remain the same. You are to have no further contact with Shaliqua, Velvet, and Sunset Let. You're to stay 500 yards away from the location at 3000 Continental Colony Parkway. And more importantly, you cannot be in possession of any weapon and any firearm. That means you cannot have any firearms in your home, on your person, in any vehicle you occupy. I don't care if you own the vehicle or you're driving the vehicle or you're a passenger. You cannot have a weapon in that vehicle or anywhere near you. No illegal drugs and no alcoholic beverages. If you attempt to communicate with any of the Lets, either in person, through a third party, through a phone, computer device, or any kind of social media platform, all they have to do is literally just contact the police or contact the prosecutor, and you will be arrested and brought back to jail. Do you understand? This is a very, very serious matter. And the only reason I'm allowing for reduction of bond is that because you have been in custody now for almost a month. So unless you love staying at the jail, I highly recommend that you comply with these conditions. Mr. Findling, I'm going to reduce the bond to $3,500. All conditions remain the same. You can draft the proposed amended order and send it to Ms. Catalia Middlebrooks. Her email should be on the chat.
Okay, perfect. Will do, Your Honor.
All right, do you see her email on the chat? I'm sorry.
Let me see here.
Yeah, I logged in late.
Yes, I do. Yes, I do.
Okay, excellent. Thank you. All right, Attorney Sharice Challenger needs to speak to position 20, Anthony Shields. Is Anthony Shields in courtroom 2? We're concluded with Mr. Poole. Thank you.
Yes, Your Honor. She can call 22392.
Okay, Ms. Challenger, if you'd like to call 404-612. 2392.
2392. Good morning, Judge.
Good morning. I believe
All right,
he's
thank you.
22392.
That's
2392.
correct.
Okay, thank you. I'll call now.
Your Honor, we have
Yes, sir.
position number 10, Mr.
In
Lloyd.
In courtroom 2. Okay, thank you. All right. Good morning, folks. My name is Judge Lal. This is the all-purpose calendar. It's a list of misdemeanor criminal cases in which individual cases have already been accused. And there are still some folks who have been given a bond, but still remain at the Wright Street facility. So I'm going to be addressing your cases on a one-on-one basis. Please remember, these are active criminal cases still pending against you. So do remember your right to remain silent. Anything you say during the course of this virtual recorded proceedings, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, we have counsel from the Public Defender's or Conflict Defender's Office to represent you. Position number 10 is State versus Sanchez Deontay Lloyd, case number 21 CR 005282J. Mr. Sanchez has been accused of simple battery and willful obstruction of an officer from July 31st, 2020. Mr. Lloyd, you've been advised of your right to remain silent, and your attorney is going to be Ms. Catrice Helen. As I understand, Mr. Lloyd, you will be entering a plea of not guilty, and then we will address your bond. Okay. Ms. Helen, has there been a change of position in that case?
Yes, Judge. We would actually like to ask for a bond modification, Judge. Currently, I have that the battery, simple battery set at $250 surety. The obstruction is $250 surety. I am asking for that to be modified to a signature bond of the same amount, Judge. When I spoke to Mr. Lloyd, he is definitely contesting these charges. That's why we're entering a plea of not guilty, Judge. And Judge, he would like to be able to get back out to the community, to get back working, to get back to his family, Judge. So that's why we're asking for that modification. If not the signature bond, then for it to remain the surety bond of $500.
Okay. So we can unmute courtroom 2, please. And Ms. Helen, do you waive a reading of the accusation?
Yes, Judge.
All right. So, Mr. Lloyd, I understand that you would like your bond modified, but you'd like to plead not guilty and have to go to trial, correct?
I really want to get time.
Wait, hold on, Mr. Lloyd. So when the judge asks you something, you got to just say yes or no. But if you have a question about how to handle your case, we can talk about that off screen, okay?
Oh, okay.
So, Ms. Helen, am I arraigning the case, or would you like to confer with your client?
Yes, arraign it, Judge, please.
All right. So, Mr. Lloyd, from what I understand, that at the present time, you're going to plead not guilty, and that your case will be scheduled for trial, but we will address your bond after the arraignment. You're shaking your head. So do you have a different position?
I do.
Okay, Judge, can I just, we hold on him, courtroom 2, can you give me a call?
When we address other cases, Ms. Helen, you may call the jail. The number is 404-612-2392. Deputy, we're going to hold off on Mr. Lloyd. He hasn't decided what he wants to do.
Hey, Ms. Helen, you got 2 people ahead of you. You got Filing on the phone with his client, and then Ms. Challenger is gonna call her client.
I understand, Judge. I'm positions 1 through 12, and then Mr. Finling is positions 13 through 22.
Got that. Do we have anyone from positions 1 to 12, with the
I have
exception of
Mr.
position
Martel Jones, position number 9.
Thank you, sir.
Johnson? Martel Jones, come on.
All right, we have State versus Martel Jones, case number 19 CR 006-381Y. Mr. Jones is accused of criminal trespass from June 12, 2019. Mr. Jones, you've been advised of your right to remain silent, and your attorney is Ms. Catrice Helen. I understand this is going to be a non-negotiated plea, which
Yes,
means
Judge.
that the prosecutor is going to give me a recommendation of a sentence if you decide to plead guilty or no contest to the charge, and then your attorney will give me the alternative recommendation. I will let you know which recommendation I'm going to accept before we proceed with the plea hearing. Do you understand, Mr. Jones?
Yes, ma'am.
Thank you. Ms. Webb, good morning.
Good morning, Judge. The state is recommending in Mr. Jones' case 12 months to serve, 30 days, credit for time served, balance suspended, a stay away from 111 Boulevard Northeast, which is the Chevron gas station, and no alcohol, drugs, or weapons.
And how many days has he served already?
Your Honor, as of today, I believe it is exactly 30 days.
All right, so he would be released and he won't be on probation, but he needs to stay away from Chevron. Is that correct?
Yes, Your Honor. The defendant was actually issued a previous warning to stay away from that Chevron by the same responding officer just less than 24 hours before this incident, Your Honor. He had also been told by the management at that Chevron to not return, or they would call the police. He returned the day prior and they did call the police. Responding officer came out and just issued a warning instead of arresting him. They call again the following day to tell him that, hey, he has returned. And the officer then proceeds to proceed with the arrest since he did issue him a trespass warning. So we want to ensure that the defendant is fully aware that the management at that Chevron does not want him to return to that property or its vicinity.
All right. I'm perplexed, Ms. Helen. Why is this a non-negotiated plea?
Well, Judge, the offer was 12 months of probation. So when I spoke to him, so we have asked about the formation of the offers. I just wanted to be on point, Judge. So we, again, are asking for it to be balance suspended. And since it is balance suspended, with clarification today, this will be a negotiated plea, Judge.
All right, thanks. Do you stipulate to venue, factual basis and ID?
Yes, Judge, we do.
Thank you. Could we unmute courtroom 2, please? Mr. Jones, it appears that you won't be on probation, that the 30 days counts towards your sentence. And then if you decide to plead guilty to this charge, this will conclude the case, but you cannot return to the Chevron gas station at 111 Boulevard. Would you like to proceed with this plea?
Yes, ma'am.
All right, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Mr. Jones, are you you can put your hand down. Are you under the influence of any kind of medication, drugs, or alcoholic beverages?
No, ma'am.
Have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with the representation of your attorney, Ms. Helen?
Yes, ma'am.
And if you decide to plead guilty to this charge of criminal trespass, you do realize that you have to give up your rights to ever go back to court, to have a trial before a judge or a jury, confront your accuser, have the assistance of counsel to argue your case, challenge the state's evidence, present your defenses, as well as have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Is anyone forcing you or inducing you to take this plea today?
No, ma'am.
How do you plead to one count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 30 days, balance suspended. You are to stay away from the Chevron gas station at 111 Boulevard in Atlanta, Georgia. If you return to that location while the criminal trespass warning is still active, you will be arrested again and brought back to jail facing a new case. Do you understand, sir?
Yes, ma'am.
Thank you. That concludes this case.
Thank you, Judge.
So I'll be released today?
If you have no other cases holding you, you'll be released within 24 hours.
Okay, thank you.
Thank you.
Your Honor, we have position number 8, Mr. Demetrius Johnson.
Thank you. Mr. Demetrius Johnson is case 19 CR 009574Y, accused of simple battery, domestic violence, reckless conduct, and cruelty in the 3rd degree from a May 23rd and May 24th, 2019 incident. Mr. Johnson, you've been advised of your right to remain silent, and your attorney is Ms. Catrice Helen. Ms. Helen, are we still proceeding with arraignment?
Yes, Judge.
And do you waive a reading of the accusations?
I do, Judge.
Mr. Johnson, I understand that you would like to plead not guilty and proceed with trial in the future, after which we will, all right, we have a shaking of the head again. So, Mr. Johnson, if you please step back, we cannot address your case at the present time. This is another case where Ms. Helen would have to talk to her visitor. All right. Ladies and gentlemen, if you have taken a different position from what your attorneys understood it to be, based on your conversations with your attorney, I cannot address your case today. You would either have to wait later today or possibly face a continuance of your case to another day. So if you have a different position from what from whatever your conversations you had with your attorney, please let us know when you call your case so that you will be given an opportunity to speak to your attorney or deal with your case another day. Thank you. All right, who do we have in the seat, please?
We have Mr. Christopher Jones. I believe he's an add-on, position 2.
Thank you.
And, yeah, just position 2. I'm sorry, Your Honor.
No problem. Thank you. All right. We have Christopher R. Jones. And Miss Helen, do you represent Mr. Christopher Jones? I'm sorry, Mr. Howard?
Yes, Judge. I'll be representing Mr. Jones. Good morning.
Thank you. Good morning. All right. We have State versus Christopher R. Jones, case number 21 CR 0057958. Mr. Jones has been charged with a misdemeanor offense from August 17th, 2021. Mr. Jones, you've been advised of your right to remain silent, and your attorney is Mr. Derek Howard. Mr. Jones, are you aware of the one misdemeanor offense that's been brought against you?
Yes.
All right. Mr. Howard, I understand this is going to be a non-negotiated plea. Is that correct?
No, Judge. Actually, after further conversation, this is going to be a negotiated plea.
Negotiated plea. Okay.
Yes.
So, Mr. Jones, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Ms. Mitchell, what is the recommended plea in this negotiated issue?
Your Honor, it's going to be 12 months to serve, 120 days confinement, credit for time served 78 days, balance probated, no further contact with victim Navarro, spelled Navarro, Farias, Farias, SDET, and no alcohol, drugs, and weapons.
All right. Mr. Howard, are those the terms to which your client has agreed?
That is correct, Judge. And we do stipulate the venue and ID and a factual basis for the plea this morning.
All right, thank you. Mr. Jones, I understand that you'll be entering a guilty plea to the misdemeanor offense brought against you. First of all, I need to ask you if you're under the influence of any kind of medication, drugs, or alcoholic beverages.
Ma'am.
I can't hear you.
No, ma'am.
Are you satisfied with the representation of your attorney, Mr. Howard?
Yes, ma'am.
You need to put your mask back on over your nose, and you just need to speak loudly through your mask.
Okay.
Thank you. And is anyone forcing you or inducing you to take a plea today?
No, ma'am.
If you decide to plead guilty to this charge, you do understand that you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to have the assistance of counsel to challenge the state's case, confront your accuser, examine witnesses, present your defenses, as well as have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
You would also have to give up your right to appeal my sentence or modify the sentence in the future. Are you prepared to give up that right?
Yes, ma'am.
How do you plead to the misdemeanor offense brought against you in case 21 CR 0057958?
Guilty.
Accept your guilty plea. Your sentence is 12 months to serve 120 days. Credit for time served 78 days. So technically your time served at the jail will be concluded. If you have no other cases holding you at the Fulton County Jail, you will be released within 24 hours.
Okay.
Within 40, is that correct?
Yes, Judge. I'm sorry. I was going to ask for one additional thing.
What were you gonna ask for?
Just that the probation fees be waived, Judge, The classes can be quite cost prohibitive. He's been in custody for almost 80 days, and so money's going to be an issue for him. So we'd ask that the probation fees be waived.
All right. I will waive probation fees for the first 6 months
Thank you, Judge.
on release. Mr. Jones, as I was saying, once you are released, you have 48 hours to report to your probation officer, and you will be on probation for the rest of the sentence. While you're on probation, you are to have no contact with Navarro Farias. You're to complete a program referred to as the SDET at your expense. Within 60 days of being released, you must show proof to your probation officer that you have enrolled in such a program at your expense. That is why your probation fees are going to be waived for the first 6 months of your release, including the months of January and February, through the end of June 2022. After that, on July 1st, 2022, you will continue to report to probation and you will start paying probation fees. So between now and July 1st, please make sure that you use every concerted effort to get employment so that you may start paying your probation fees from July 1st, 2022 onwards. That concludes the case. Thank you.
Thank you.
Oh, no illegal drugs, no alcoholic beverages, no weapons, no firearms. Thank you.
Thank you.
Position number 15.
Are we addressing 3 South? All right. Mr. Asher Zadikia McBee, is that correct?
Yes.
Mr. McBee, am I addressing you?
Certainly. Thank you.
Yes or no?
Yes, thank you.
Your case number is 21 CR 006640C. You've been accused of criminal trespass from a November 19, 2021 incident. Mr. McBee, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Zach Finley. Mr. Finley, I understand this is going to be a negotiated plea. Is that correct?
Yes, Your Honor.
Thank you. Mr. McBee, may I place you under oath, please? You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes.
Ms. Mitchell, what's the recommendation for Mr. McBee?
The recommendation is time served, 56 days confinement, credit for time served, 56 days, balance suspended. Well, no necessary. That's not necessary. Stay away from Motel 6 on 311 Cortlandt Street, Northeast, Atlanta, Georgia. That is all.
Mr. Finley, are those the terms?
Yes, Your Honor. Those are the terms. We agree to the state's recommendation. And additionally, we do stipulate to the factual basis, venue, and ID, Judge.
Thank you. Mr. McBee, are you under the influence of any kind of medication or drugs?
No, Your Honor.
And are you satisfied with the representation of your attorney, Mr. Finley?
Yes, Judge.
Is anyone forcing you to take a plea today?
No.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, confront your accuser, examine witnesses, challenge the state's case, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights? Sorry?
Yes. Yes, Your Honor.
How do you plead to 1 count of criminal trespass?
Guilty.
Your sentence is time served. If you have no other cases holding you at the jail, you should be released within 24 hours. You cannot return to the Motel 6 at 311 Cortlandt Street in Atlanta, Georgia. And if you return, you will be arrested again and brought back to jail. Do you have any personal belongings at that location?
No.
All right, that concludes this case. Thank you. Courtroom 2, who do we have, please?
This is Rayfield Simpson
Mr. Rayfield Majiti Simpson has two cases before us. The first one is position 21, case number 21 CR 007-590Y, accused of criminal trespass and loitering and prowling from December 13, 2021. This second case is position 22, case number 21 CR 005-296Y, in which he's been accused of simple battery from October 6, 2021. Mr. Simpson, you've been advised of your right to remain silent. Your attorney will be Zach Finling. And Mr. Finling, I understand in both matters, this is going to be a plea hearing. Is it settled that it is a non-negotiated plea?
Non-negotiated plea, Your Honor.
All right. Ms. Mitchell? All right. So, Mr. Simpson, I'm first going to hear the recommendation from the prosecution, and then I will hear from your attorney. Before we proceed with the plea hearings in both cases, I will let you know which recommendation I'm going to accept. Do you understand, sir?
Right.
Ms. Mitchell, what's the recommendation for positions 21 and 22?
For position 21, the recommendation is 12 months to serve, 60 days confinement, credit for time served, 30 days, balance probated, no further contact with victim Marcella, Marcella Adams, a stay away from 1040 Huff Road, Northwest Atlanta, 40 hours community service, and no alcohol, drugs, and weapons. As to position 22, the recommendation is going to be 12 months to serve, 60 days confinement, credit for time served, 30 days, balance probated, no further contact with victim Philpott Dante, spelled Philpot Dante, Dontaye, stay away from all MARTA bus stations, 8-week anger management, and no alcohol, drugs, and weapons.
And are these sentences to run concurrent? With the
Yes, Your Honor.
exception of the programs?
Yes, Your Honor.
All right. Mr. Finling, what's the defense seeking?
Yes, Your Honor. We are asking for the community service to be waived. As we know, the 40 hours does end up coming to a lot more than that, coming to and from. As well, finances have been an issue throughout Mr. Simpson's life. And since his time being incarcerated, he has actually arranged to work once he gets out at a pay center. And he's going to use that money to provide for himself, get back on his feet, and provide for his two daughters. So we are asking for the probation fees to be waived. We are asking for the 8-week anger management to be reduced to 2-week anger management. And once he satisfies those conditions, that condition for the balance to be suspended.
So normally someone gets imposed with a fine, a $1 fine, and then they ask me if they can convert that to community service. So now you're asking me to completely waive community service for 2 active cases that occurred within a short span time. I will be willing to do that, and I can impose a $400 fine. So which one would Mr. Simpson like? To do voluntary community service and give back to the community, or would he like to pay a $400 fine? Could we unmute courtroom 2?
I like to do community service.
All right. Mr. Finling, I'm going to accept the state's recommendation. Mr. Simpson, if you decide to plead guilty to both these cases, your sentence you already serve your time at the jail. You'll be placed on probation. I will waive your probation fees for up to and including June of 2022. While you are on probation, you are to complete 40 hours of voluntary community service, which you can complete over the rest of the 10 months left on probation. You are also to complete an 8-week anger management program at your expense, which you may take up anytime during the 10 months, but you must enroll in that program within 6 months of being released. Do you understand?
Yes, ma'am.
And at all times, you have to stay away from all MARTA facility as long as you have an active suspension against you,
Say it one more time. Yes, ma'am.
right? So if there's no active suspension, you can return to MARTA, but if there is an active suspension, you cannot use MARTA. Do you understand?
Yes.
Is that something you want to accept?
I accept the guilty.
Do you want to accept those terms?
Yes.
Mr. Finling, are you confident that we may proceed?
Yes, Your Honor.
All right. Mr. Simpson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
And Mr. Finling, we stipulate to at least the venue and ID, correct?
Yes, Judge.
All right. Mr. Simpson, are you under the influence of any kind of drugs, medication, or alcoholic beverages?
No.
And are you satisfied with the representation of your attorney?
Yes.
Is anyone forcing you or inducing you to take a plea today?
No.
If you decide to plead guilty to the charges brought against you in both these cases, you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to have the assistance of counsel to challenge the state's case, confront your accuser, examine witnesses, present your defenses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
In case 21 CR ending with 7590Y, how do you plead to one count of criminal trespass and loitering and prowling?
Guilty.
Excuse me?
Guilty.
Your sentence is 12 months to serve 60 days, credit for time served 30 days, balance probated. Your probation fees will be waived for the first 6 months. You're to have no further contact with Marcella Adams and to stay away from 1040 Huff Road, complete 40 hours of voluntary community service and not consume any illegal drugs, no alcohol, beverages, no weapons, and no firearms. And these sentences will run concurrent. With regards to position 22, 21 CR ending in 5296Y, how do you plead to one count of simple battery?
Guilty.
Your sentence will run concurrent to position 21, and the sentence is 12 months to serve 60 days, credit for time served 30 days, balance probated. Your probation fees will be waived up to and including June of 2022. You will continue to report to probation, and you will start paying probation fees from July 1st, 2022 onwards. With regards to this second case, you have to have no further contact with Philpott Dante and to stay away from all MARTA facilities while there is an active suspension against you. You're also to complete an 8-week anger management program, which you can complete anytime during the 10 months while you're probation, but you must enroll in that program within 6 months of being released. Understood?
Yes.
All right, so between now and the term of probation, I would recommend that you start saving up your funds because you'll need to pay for your anger management program. Understood?
Yes, ma'am.
Thank you. Anything else, Mr. Finley?
No, Your Honor.
All right, that concludes position 21 and 22. Thank you.
Position number 2.
All right, thank you. I'm at 3 South addressing State versus Johnny Lee Barnes II, accused of criminal trespass and solicitation in a Atlanta City ordinance violation, charged as aggressive panhandling from December 15, 2021. Mr. Barnes, your case number is 21 CR 007583E. You have a right to remain silent. Anything you say about the facts of the case during the course of this virtual proceeding, your statements can and will be used against you. You have a right to an attorney and you're represented by Ms. Catrice Helen. Ms. Webb, Ms. Helen, are we still proceeding with a non-negotiated plea?
Well, Judge, the only thing that's at issue is whether it be balanced, probated, or suspended. So that's the only issue, Judge. It would be a negotiated plea, but.
Ms. Webb, what is the state's recommendation?
Yes, Your Honor, that is actually a balance suspended on both counts for the trespass and solicitation, Your Honor.
All right, if that issue has been resolved, then this is a negotiated plea. Mr. Barnes, would you like to still proceed with the plea hearing? You need to speak up.
Yes, ma'am, Your Honor.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Webb, what's the recommendation, please?
Yes, Your Honor, the state is recommending for the count 1 on trespass, 12 months to serve 30 days, credit for time served 30 days, balance suspended, a stay away from the 506 Moreland Avenue Northeast address, which is the Starbucks on Moreland, Your Honor. For count 2 for solicitation, 6 months to serve 30 days, credit for time served 30 days, balance suspended, and that runs concurrently with count 1.
All right. Ms. Helen?
And yes, Judge, we accept the state's recommendation and we stipulate to the factual basis, venue, and ID.
All right. If I'm not mistaken, isn't this the Starbucks across from what used to be called Grady High School? No, it's not. It's a different one.
That's right. That's
No,
right.
nothing. I was asking the prosecutor something. I've got my geography wrong. All right. Ms. Helen, I'm sorry, did you say you stipulate to factual basis, venue, and ID?
Yes, Judge.
Okay. Mr. Barnes, first of all, are you under the influence of any kind of medication or alcoholic beverages?
Medication.
Speak up.
Medication from, I'm on psych.
Well, all right. So you are under some kind, you have consumed some kind of medication, is that correct?
Yes, ma'am.
And even after consuming that medication, are you able to understand the proceedings so far?
Yes, ma'am.
Are you able to make a decision as to whether you want to plead guilty to this charge of criminal trespass and aggressive panhandling?
Yes, ma'am.
Are you satisfied with the representation of your attorney, Ms. Helen?
Yes.
And is anyone forcing you or inducing you to take this plea today?
Ma'am.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, challenge the state's case, present your own evidence of defenses, confront your accuser, examine witnesses, as well as have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass and 1 count of aggressive panhandling?
Guilty.
With regards to your sentence, it's for the criminal trespass is 12 months to serve 30 days, credit for time served 30 days, balance suspended. You are to stay 200 yards away from the Starbucks shop at 506 Moreland Avenue. 200 yards away means the length of 2 football fields. Do you understand, sir?
Yes, ma'am. Is that on the road or is that the perimeter of the Starbucks itself around?
Well, you know the entire shopping complex around that Starbucks?
Yeah.
You cannot go back to that entire shopping complex.
Can I walk up the other side of the road?
Nope.
Okay.
On the other side of the road.
Okay, I'll stay 200 football fields away from
200 yards away.
200 yards? Okay. Oh, yeah.
On the aggressive panhandling, your sentence is 6 months to serve 30 days, credit for time served 30 days, balance suspended.
Yes,
sentences run concurrent. Thank you, sir.
Thank you, ma'am.
Do we have anyone else at 3 South?
So I can go home now?
Within 24 hours, you'll be released. Hopefully you have no other cases holding you.
Okay,
thank you.
Good morning, Your Honor. This is a Spanish interpreter.
Yes,
I have a case, but I just sent something in the chat that I have a couple of pleas at 10. So I was wondering if the case is ready, or is not, if not, I can come back a little after 10.
All right. Miss Helen, Mr. Finling, do you have a client who needs a Spanish interpreter?
No, Judge, I don't.
Mr. Finling?
Yes, I do, Your Honor.
And his name?
Mr. Martinez.
Position 1213. Is he on the add-on?
Yes, Your Honor, he is a add-on.
All right. Do we have Mr. Conrado Martinez Guneta anywhere at the facility?
I'm
Mr.
sorry, Judge. Can you repeat that again?
He's position 3 on the add-on calendar. Conrado
Looking for?
Martinez Cuneta.
He's quarantined, Judge.
All right. Mr. Finling, it looks like we won't be able to address him today. We'll have to reset him to next Thursday, which is going to be, what's the date for next Thursday?
Hey,
20th.
Judge, Mr. Finling, I don't know if he has a time served deal, so if we could put him on the Tuesday so that he wouldn't have to be in incarceration for that
Okay,
amount of time.
reset to January 18.
Thank you, Judge.
Thank
Thank
you.
you, Judge.
All
May I
right.
excuse, Your Honor?
Yes, Mr. Sedano, thank you so much.
Thank you.
Have a
my
good
pleasure.
day.
You too.
And I'm sorry, who do we have in courtroom 2 right now?
Position 10, Mr. Lloyd.
All right, Mr. Lloyd Sanchez has had a conference with his counsel, hopefully, and we're returning to case 21 CR 005-282J. And Miss Helen, what's the announcement?
Judge, this will be a non-negotiated plea.
Okay, so
And-
Mr. Lloyd, I'm sorry, I'm going to let Ms. Webb proceed. Mr. Lloyd, I understand that you want to enter a plea, and this is going to be a non-negotiated plea, which means that the prosecutor is going to give me a recommendation, and then I'm going to hear from your attorney. Before I proceed, I will let you know which recommendation I'm going to accept, and then you can make the decision as to whether you want to move forward with the plea of guilty or whether you want to enter a not guilty plea and have a trial. Do you understand? All right. And you've already been advised of your right to remain silent. So Ms. Webb, what is the recommendation for Mr. Lloyd?
Yes, Your Honor. The state is recommending for Mr. Lloyd 12 months to serve, 120 days. That would be 90 days for the battery charge and 30 days for obstruction, balance probated, family violence and intervention program enrollment, a stay away from the J&J grocery located at 507 Joseph E. Laurie Boulevard, no further contact with the victim, Ms. Tyisha Jackson, that's Tyisha Jackson, 80 hours of community service, 50 for the battery, 30 for the obstruction, and these charges do run concurrently, Your Honor. As Your Honor knows, Your Honor, we are making this recommendation based off of the facts of this case. When the defendant was arrested, the officers were responding to a dispute call at the J&J grocery on Joseph E. Laurie Boulevard. And upon arrival, the officers was actually witnessed the defendant attacking the victim, Ms. Jackson, outside of the store. The officer also witnessed Ms. Jackson attempting to evade and flee the defendant, Your Honor, and she ran into the grocery store. And at that point, the officer exited his vehicle and sprinted behind them. The defendant was tackling Ms. Jackson inside of that store and attempting to punch her with a closed fist. The officer commanded him to stop, and he refused to listen to those commands. And the officer actually had to tase the defendant in order to actually get him apprehended and arrested, Your Honor. Additionally, we are concerned, the reason why we did give such high number of community service hours and the time to serve, Your Honor, is because the defendant was recently released just the previous year on a simple battery charge and terroristic threats, where he had a $31,000 surety bond of March of 2021 against a woman named Miss Tyisha Lum, where he threatened to kill and stab her. So we are concerned that, you know, he will reoffend if the state does not intervene and provide him with some resources regarding anger management, and also honoring our duty to the community and the victim to ensure that he does not offend anyone else again.
All right. So it's 120 days credit for time served. He's been in custody now for what, 16 days?
Yes, Judge.
Yes, Your Honor.
All right, so how much more time is the state seeking?
There's 54 additional jail days,
54
Judge.
more additional days, okay. And does he have an open case right now in Superior Court?
Yes, Judge.
Yes,
Okay.
Your Honor. I believe that is for an aggravated assault case in armed robbery.
No, I don't see an armed robbery, it's just assault
Aggravated
and
assault.
battery.
Yes, Your Honor. You are correct. I'm sorry.
That's
Reading
right.
the wrong dates.
All right. Ms. Helen?
Yes, Judge. After speaking with Mr. Lloyd, this is a non-negotiated plea. I am asking for time served. Currently, he has been incarcerated for 16 days. We do agree that the balance will be probated for the family intervention class. We understand the stay away from the 507 Joseph E. Boulevard. We are asking for the community service to be reduced from 80 to at least 30, Judge, to make it manageable for Mr. Lloyd to actually complete those. He has lost all employment due to being incarcerated these days, Judge. And so we want to give him an opportunity that if it is granted community service, he can actually make the community service and complete it. So Judge, that's why we're asking for a recommendation of time served. And again, we do understand the stay away as well as the family intervention program classes.
All right. Ms. Webb, can you explain to me how this incident occurred on July 31st, 2020? Was he released on bond at that time?
Your Honor, I am showing that he was released I see that he was released on August 21st, 2020 on that $31,000 surety bond. Excuse me, Your Honor, that was March 1st of 2021 on that those previous simple battery and terroristic threats charges. I am seeing that far as this case, Your Honor, give me 1 second. I just want to make sure I'm getting all of my dates correct.
Okay, I see. It was a bind over case from City of Atlanta.
He had other charges from what I'm interpreting is that he had other charges that were upgraded to felonies or were automatic felonies. Mm-hmm. So he's being prosecuted in our office as well as in the VA's office, Your Honor.
I see. Okay. All right. And I was just trying to figure out why we don't have a booking for this particular case. Ms. Helen, under the circumstances, given Mr. Lloyd's significant criminal record history set forth, I'm looking at I will address her. I got it. And given the factual basis of this, the warrant, I'm inclined to accept the state's recommendation, but I do have a witness in the courtroom at the present time. I understand that she's a relative of Mr. Lloyd. And ma'am, if you could come all the way across, not through those double doors, to that microphone right there. All right. No, I didn't forget you. I was just trying to figure out what was going on. All right.
Thank you, Your Honor.
If you could please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Lord, I do, yes.
All right.
Yes,
Could you
Lord.
please identify yourself?
Yes, my name is Kathy Holiday, mother of Sanchez Lord.
All right. And Ms. Holiday, are you familiar with this case?
I am.
All right. Are you familiar with the other cases that he has pending against him?
I am.
All right.
Very well.
So the issue I have right now is whether to accept a recommendation that the time he served in jail for this particular case from July 2020 concludes the matter, but he has other cases holding him at the jail.
That's what I was told, and I know why.
All right. And the state's asking that he served another 54 more days at the jail for this charge.
Oh my God, he needs to be out. My son,
all right, please explain why he should be out.
My son has been suffering through bipolar disorder since his father was killed he was like 15 or 14 years old. His father was involved in a shootout he had nothing to do with. His father was accidentally killed. His father's friend with a crossfire. Him and a guy got into an argument. The guy came back and shot up the van that his Sanchez father was in, and he was hit by the bullet.
Who was hit by a bullet?
Sanchez's father in 2000.
Okay. So as a result of the incident?
It did something to my son.
Okay.
It really did something. Took away his father for no reason. His father had nothing to do with it. He was killed in a crossfire. And Sanchez haven't been right since. I have back and forth been trying to take him to the doctor, you know, he even try to get self-help. And like I was asking her, you know, how to become power of attorney, because every time I make an appointment, they would not let me do it. They said, Sanchez is grown, let him do it. And every time he keep getting into it with people because he's hurt, he's angry. And, you know, his father got killed. It's been 20 years, but some people never get over death, loved ones. Then he met someone later on, this girl from New Jersey. She just died in 2019, 29 years old of a heart attack. That did something to him again. He has a lot of hurt. I see the pain he goes through. Like he just losing people. He's a good son. My son graduated from high school and everything. It just ever since his father got killed like that, no one was never charged either, because the bullet never got out of his father's head. They could never point the finger at the two guys that, you know, had the
I understand it's tragic about what happened to his father, but my concern is that I'm looking at his criminal record history. It is numerous since 2012.
Because he's sick.
All right.
He's sick. He don't mean to. He's a good person. It's on and off. It's that bipolar. Please read on the bipolar. I've been had to read on it myself to get an understanding why my son got angry at him. And sometimes he's good. He said, Mom, it's like this. I have split personalities. He said, the devil pulling me this way and God pulling me this way. He said, I want to do right, but something, it's unbalanced in my head. He said, I need help. He told me that. He said, someday he want to hurt himself. He might want, you know, he never told me he want to hurt people. He just said, someday he want to hurt. He said, he has no reason to live no more. He don't have no reason to live.
All right, Ms. Holland. I'm so sorry for your situation, but I also have to weigh the community interest in mind. Okay. Okay. Please be patient. Ms. Webb, do you have any questions to ask of Ms. Hollywood, right?
Holiday.
Excuse me.
Yes, Your Honor. You know, the state is indeed empathetic to the facts of Mr. Lloyd's past, Your Honor. And in no way am I implying that those facts are not important, Your Honor. But at the same time, our office has a duty to, of course, protect the interests of the community, and in particular, the interests of the victim in this case, Ms. Taisha Jackson. Now, whether or not Mr. Lloyd will be released and be able to receive the adequate resources to get those mental health concerns adequately addressed by either entering into a program of something of that nature or getting treatment. As the state, I'm not opposed to, Your Honor, adding in a condition that he does start in that process of, you know, getting the adequate treatment that he needs. And if his mother wants to take on that burden and responsibility of assuring that, as well as reporting to the court while he's on probation, that they are making those changes and progressing towards finding a solution for his mental health concerns, the state is not opposed to that. But far as amending the recommendation because of those pre-existing conditions, Your Honor, the state is opposed to that because this is not his first time coming in contact with this court, Your Honor. This is not his first time coming in contact with the judicial system, Your Honor. And the nature of the violence and the fact that it happened in a public space, the fact that the defendant was not able to control himself when the officer told him to stop, when other people and passerbys were also sitting there witnessing this act, Your Honor, even the management of the store attempting to intervene. But of course, most people don't intervene, Your Honor, because you never know if somebody has a weapon or what they would do in retaliation. So to that end, Your Honor, we are requesting that our recommendation continues to be honored. But we are not opposed to adding in a condition where the mother, Miss Holiday, and the defendant do agree to start the process of reporting to the court what measures are being taken to address those mental health concerns, because the state is empathetic to that. And we do want him to get the rehabilitation and resources and medication and treatment that he needs. But at the same time, Your Honor, we do have to honor our duty to the community to ensure that when these events happen, that we are adequately addressing them while also addressing some of those concerns that the defendant's family has expressed today in court.
If Ms. Webb, if you are acknowledging what the Ms. Halliday has just announced to us, what would the benefit of an FVIP be in lieu of if we do an MHET and with anger management classes? And then on the same side, I'm also concerned about 80 hours of community service if there is such issues surrounding Mr. Lloyd, I'm a little concerned about allowing him to engage in voluntary community service and have contact with the community until he's more stabilized.
Yes, Your Honor. And those are definitely reasonable amendments. I am not opposed to having, instead of the FVIP doing the anger management courses, I would suggest a 12-week anger management course for the defendant, Your Honor, in lieu of the FVIP. We did recommend the FVIP because from my understanding, Ms. Taisha Jackson is a former lover, or there is an intimate relationship there, Your Honor. Additionally, we do know that that program does include anger management courses as well. So it was kind of a, killing two birds with one stone, if you will, Your Honor. As far as the community service hours, if the argument is that, he's not stable to be able to commit to those, or that he may cause issues for the program coordinators, then I am also willing to waive that, Your Honor. But I don't know if I'm willing to waive. I don't think the state is willing to waive the full 80 hours, Your Honor. I think he should be at least commit to half of the time for 40 hours.
All right.
Unless there's, again, unless we are coming to the conclusion that he's unstable. And if that's the case, he should submit himself to a mental health eval.
I don't know. I don't have a prognosis other than what Ms. Halliday has attested to.
Yes, Your Honor.
Ms. Helen?
Yes, Judge. So I just want to make sure I'm hearing all of the arguments. Is the offer now MHET, the anger management program, as well as some type of community service?
It's 12 months to serve 120 days. Credit for time served 16 days. You would have to serve 54 more days at the facility to complete a 12-week anger management, balance probated, during which he needs to complete a 12-week anger management program, an MH evaluation and treatment if recommended. He must be compliant with all MH programs and medication. He needs to stay away from the J&J grocery store at Joseph E. Boulevard, have no further contact with Taisha Jackson, and 40 hours of community service.
Mr. Lloyd, the judge has agreed to accept the state's recommendation of the previous conditions mentioned, the 40 hours of community service, the anger management course, and as well as the judge, you say the MHET?
Yes.
But the judge has agreed with the state to add the 50, or excuse me, sentence you, give the order of 54 additional jail days. Do you accept that, or are you pleading not guilty?
Not guilty.
Okay, Judge, we're pleading not guilty, and I'd ask for a bond hearing.
All right, thank you. Mr. Halliday, if you please have a seat. Mr. Lloyd, you've been advised that you're accused of simple battery and obstruction of a law enforcement officer from July 31st, 2020. Given the charges brought against you, you do have a presumption of innocence, and upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecution has the complete burden to prove the charges against you beyond a reasonable doubt. If the state succeeds in carrying its burden of proof, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. The sentences could be served separately, or they could be served together concurrently. Given this information, how do you plead? Please agree. Your case has been arraigned and will be further noticed for trial. Ms. Helen, with respect to the request for a bond, he presently has a $500 surety bond. He has a $93,000 surety bond in his other case. What are we talking about at the present time?
We're talking about the $500 surety bond as set for the simple battery, $250, obstruction as set as $250. Judge, first, we're asking for a signature bond. And if not the signature bond, we are asking that the bond remains as it is set $500 surety, Judge. Mr. Lloyd is 34 years old. As you've heard, he's been incarcerated for the last 16 days. So he's lost any employment or forms of income to help him, Judge. And also, as you've heard from his mother, there are some MH situations that he is currently needing help to get support in, Judge. So that's why we're asking for the signature bond, so that him and his mother can group together and be able to help him with those MH issues, keep him stable. Now, the Ayala factors have him show up to his court dates. He will not be a danger to the community, judges, as we've mentioned here, because he understands that he has an open case. He won't be released on that, Judge, unless he bonds out. So I do not believe he'll be a danger to the community. And as far as intimidating the witness, Ms. T. Jackson, he understands there is no contact with that individual at all, Judge. So based on the Ayala factors, I am asking for that signature bond, and if not, keep it as the surety bond of $500.
I don't have a problem keeping it at $500 surety bond. That should be fine. He's in jail right now for 16 days, not because of this case, not because of the incident from July 2020. He had already bonded out from City of Atlanta. This case was bound over to us. He was never booked at the Fulton County Jail because of this case. So I want to make the record clear also that Mr. Lloyd is at the Fulton County Jail because of a brand new incident that occurred in December of 2021 involving felony charges. So 500 surety bond, as set by the City of Atlanta way back, upon which he was released, I understand. But Ms. Helen, if you believe there should be a prognosis with regard, you do know that you can submit the appropriate evaluations for Mr. Lloyd to get started on the road to see if he can receive other resources as well.
Understood, Judge.
All right, this case has been arraigned and further notice for trial. And Ms. Helen, if the social worker wants to evaluate his case for a possible evaluation, I'm all open to that idea.
Judge, and I would like to get Ms. Holliday's number, mom, who's in court, if it's possible, if someone could just send me that in the chat, that would be great, Judge.
All right. We are going to put it on a piece of paper and Ms. Katalia Middlebrooks will send it to you. All right, thank you. That concludes this case.
Next,
No, ma'am, the case is concluded. Please put your phone number down and public defense attorney wants to talk to you. All right. Courtroom 2, who are we addressing, please?
Position 8, Mr. Johnson.
Judge, I was still on the call for the other case. I wasn't able to speak to Mr. Johnson, so if we could.
All right, anyone but Mr. Johnson?
Position 20, Mr. Shields.
Thank you.
Go ahead, answer that phone.
Anthony Wayne Shields is case number 21 CR 008023E, accused of battery domestic violence from December 31st, 2021. And Mr. Shields, you've been advised of your right to remain silent. Your attorney is going to be Ms. Sharice Challenger. And Ms. Challenger, I understand you want your case arraigned and further notice for trial and address bond. Has anything changed?
No, Your Honor, that is correct.
All right. Mr. Shields, I understand that you'll be entering a plea of not guilty and your case will be arraigned. Ms. Challenger, do you waive a reading of the accusation?
Yes, I do, Judge.
All right. Mr. Shields, you've been accused of a misdemeanor offense, battery domestic violence, allegedly occurring in Fulton County, Georgia on December 31st, 2021. You are presumed innocent of this charge, and upon your entry of a not guilty plea, the case will be scheduled for a trial before a judge or a jury. At the time of the trial, the prosecution would have the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
Not guilty, all right? Your case has been arraigned and we are going to address your bond. Ms. Challenger?
Yes, Judge. Thank you, Judge. Give me one moment, just checking one thing out, please. Judge, my understanding is that he had a previous bond set for $10,000. I am asking the court to reconsider that matter based on some history I'm just going to make the court aware of. He is 57 years old. He's a disabled veteran. He served as in the Marine Corps. He was injured in Beirut in combat. And as a result of that, he did have major reconstructive surgery on his knee, and he does suffer from PTSD. So he is on an antidepressant called Nutripeline. He has not taken that medication while he's been in custody, Judge. And so because he's on a fixed income, he's on SSI, he cannot afford anywhere near a $10,000 bond. I understand that there is some history, which I'm sure the state will make you aware of that. However, you know, of course, the court is aware of the whole purpose of a bond hearing is not to penalize him, but just to make sure he comes back to court. And so, Judge, we are asking for you to reconsider that. If the court is not inclined to give him a signature bond, we are asking that you would be able to give him a lower bond, which is more reasonable for him, which would be about a $1,500 bond. He does state that the alleged victim in this matter, they did live together, but he does, even though the apartment is in his name, he is from the last condition, he had no further contact, and as well as a stay away. He does say he has somewhere else to go in order to, once he gets out, and he would be able to oblige by those conditions. So because of all that information, we are actually to reconsider.
Thank you. Ms. Mitchell?
Yes, Your Honor, the state's going to request that the bond recommendation remain the same due to the egregious facts in this case, the violent criminal history of the defendant, and the fact that the defendant might be a flight risk. In this case, when officers responded to location 195 Fairburn Road, Northwest Atlanta, they met with
I am familiar with the incident that occurred with Miss Wanda Champion recently.
Okay.
Do you know of any change of circumstances?
No, Your Honor, just to emphasize the violent criminal history, our main concern is to make sure the victim is okay and that the defendant comes back.
All right. Wanda Champion, I can't recall whether she appeared at the last hearing. Have you all had any further communication with her?
Just give me one moment, Your Honor. I can take a quick look. Let me see if Your Honor, no, our victim advocate attempted contact but was unsuccessful.
All right. Bond is going to be set at $5,000. It's going to be a surety bond. No further contact with Wanda Champion, no illegal drugs, no alcohol, no weapons, and to stay away from the residence as previously ordered. Mr. Champion also has an open aggravated assault felony case involving the same victim, and the egregiousness of those allegations, as well as the ones set forth in the warrants in this case, give rise that he cannot qualify for a signature bond at the present time. Thank you.
Thank you, Judge. This completes my matter. May I be excused?
Yes, Ms. Challenger, if you'd like to submit a amended bond order, and please email that to Ms. Catalia Middlebrooks. I believe her email's on the chat, if you want to confirm.
Okay, thank you. I will do that.
Thank you. All right, that concludes Mr. Shields' case. We're moving on to position 8, Demetrius Johnson.
Yeah. Okay. Yeah, you're done.
Ms. Helen, are we still proceeding with a arraignment?
No, Judge, this will be a non-negotiated plea.
Mr. Demetrius Johnson has been advised of his right to remain silent, and his attorney is Ms. Helen, case 19 CR 009-574Y. He's accused of simple battery on May 24th, 2019, reckless conduct and cruelty allegedly occurring on May 23rd, 2019, allegedly in Fulton County, Georgia. Mr. Johnson, we are first going to hear from the prosecutor with regard to the recommended sentence, and then I'll hear the alternative recommendation from your attorney. Given the information we have so far in your case, I will then let you know which recommendation I'm going to accept before we proceed. Ms. Webb?
Yes, Your Honor. The state is recommending 12 months to serve, 90 days concurrent for all three charges, 60 days for the battery, 15 days for the cruelty to children, and 15 days for the reckless conduct. Balance probated. A stay away from the incident location at 440 Thomasville Boulevard, Southeast, apartment 145. No further contact with the victim, Ms. Wylisha Cosby. That is WYLESHA Cosby, CAUSBY, a FVIP, third party contact with the party's child, minor child, LJ, and a 80 hours of community service. That is 50 hours for the battery, 15 hours for the cruelty to children, and 15 hours for the reckless conduct, Your Honor.
All right, thank you. Anything else you want to add?
Yes, Your Honor. We are making this recommendation based off of the facts of this case. As Your Honor knows, the defendant officers did respond to a dispute call at the home where the mother of his child, Ms. Cosby, informed officers that the defendant attacked her in the home. At some point, he slapped her in the head several times after he became enraged about a job situation that she had discussed with him. The victim did inform the officers that she became dazed during that incident, Your Honor, and she was able to regain consciousness. But the child, the pair's 9-year-old minor child, tried to intervene and to protect mom, and then the defendant turned the rage against the child. The child did run down the stairs to attempt to get away from her father, and at some point fell and scraped her knee and her elbow, Your Honor. Medical was sent out to ensure that the child's knee was not dislocated, and turns out it wasn't, thank God. Your Honor, we do have concern that if, he will reoffend this Ms. Cosby, and given that there is a relationship, a familial relationship here, and the fact that they do share a child together, it complicates the facts of the situation, Your Honor. And we are concerned that, in the event that they have another argument in the presence of the child, that the defendant is not able to control his anger and will unleash that anger against not only the mother of the child, but the child itself, Your Honor.
All right. Ms. Helen?
Yes, Judge. So this is a non-negotiated plea. We are asking for a recommendation of 60 days, Judge, that essentially will be 18 additional jail days. We understand the Family Violence Intervention Program, so we will keep that there, but we are asking that the 80 hours of community service be reduced or even waived, Judge, because Mr. Johnson has lost all employment due to incarceration, okay? And he also has 3 children he is the primary caregiver of. The one that's already been mentioned to the state, and 2 other girls, one 4 weeks old, one 12 years old. So, Judge, he would need to be able to have income to and transportation to complete 80. So we're just asking if it not be reduced, waive, Judge. Furthermore, Judge, you understand that these are allegations. I have that this has been, he was arrested essentially for failing to appear. So when I talked to him and we went over the FTAs, he had no notice, Judge. I do have a change of address that was updated, but Mr. Johnson did not get notice of the 2 court dates that are alleged to have been missed, Judge. So we are asking for a recommendation of no more than 60 days. We agreed to the FFIP, but we are asking for the 80 hours to either be waived or reduced to allow Mr. Johnson to complete those, because he has 2 other children that he is a primary caregiver of, Judge. And I do have a permanent address, a mailing address of 1981 Bridle Road, Lawrenceville, Georgia, which he will be living with his mother at that location, Judge. So that's a stable address.
All right. Looks like he failed to appear on December 6, 2021. And the last updated address we had from him was in December of 2nd, 2020, a Godfrey Drive. So that's the last address we had. And if he changed his address in 2021, we don't have a notice of change of address at all. So the case went dormant on December 6th. 2021, and he was arrested on a bench warrant issued on December 8th, 2021. And he's been in custody for 8 days. So if he decides to, well, that's what I have.
I have that he also did 4 days in November 27th of 2019 to November 30th of 2019, which is an additional 4 days. So I have a total of 12 days of incarceration for this particular case, Judge.
So 12 days. So 12 months to serve 90 days. I'll give him credit for 12 days. And according to the state, how many more days would he have to serve at the jail?
33 with the state's recommendation.
I will agree to 12 months to serve 60 days, which means he has 18 more days to serve at the jail. Balanced probated. He needs to stay away from 440 Thomasville Boulevard, that particular apartment. Well, he needs to stay away from the entire complex. No further contact with Wylisha Cosby. No illegal drugs, no alcohol, and no weapons. He will be subject to random screens by probation. He would need to complete a 6-month domestic violence intervention program. I will allow for a third-party transfer of the minor referred to as LJ. He cannot go to the apartment complex to facilitate the transfer. It has to be done through a third party. And he must complete 80 hours of voluntary community service while he's on probation. So which means that he will be on probation for at least 10 months. I will waive probation fees for the first 6 months up to and including upon his release, which will be up to and including the end of July 2022. And then August 1st, 2022, he will still be on active probation and he'll need to start paying probation fees. Does your client want to proceed with this recommendation?
Yes.
Yes, Judge.
All right. Miss Helen, Miss Webb, any objection?
No, Judge.
No objection from the state, Your Honor.
All right, thank you. And Miss Helen, do you stipulate to the venue and ID?
Yes, Judge.
All right. And Mr. Johnson, if you want to proceed with the plea, I need to place you under oath. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Judge.
And
Mr.
I'm sorry, Judge. If he hasn't used his NOLO in the last 5 years, I would ask if he'd be able to use that.
For simple battery?
Yes, Judge.
Miss Harrison, do you have a record of Mr. Johnson entering a nola contendere to a simple battery or reckless
Now, Your
conduct?
Honor. I'm checking now.
And Miss Webb, the cruelty in the third degree
Yes,
on a
Your Honor.
simple battery, is that
The-
tangential or is it, what are we talking about?
They were set to run concurrently, Your Honor.
No, am I saying, is that a legal charge with the simple battery domestic violence?
As in, did they merge? Is that what you're asking?
You can't, cruelty in the third degree cannot hold against a simple battery. If you had a battery domestic violence. So I'm wondering, are you all doing it on that count or are you doing, I don't think you can do it on a reckless conduct.
Your Honor, that question I am not 100% sure of. I do know that the responding officer did cite him for the reckless conduct and the cruelty to children in the third degree because the child did sustain visible markings with the scraped knee and falling down the stairs. And according to the report, with the act of him chasing the child in the house down the stairs as well. So if I'm not mistaken, Your Honor, I believe it is through the reckless conduct charge and not the simple assault. The simple battery charge was for the mother, Your Honor.
Mr. Howard, you want to chime in?
Yes, Judge, you're on the right track, Judge. It cannot follow the charge of a simple battery, and there's no mechanism for a reckless conduct charge to be attached to a cruelty to children charge as well. So that charge would not be valid given that this is a simple battery versus a battery charge. So that would need to be merged or non-pros or something along those lines. I think And we've dealt with that issue a number of times.
I'm dismissing the cruelty to children in third degree as an improper charge, given that the collateral, if it's a predicate to the simple battery, it cannot hold as a matter of law. All right, so we are still going with the same recommendation. The sentence is going to be concurrent with regards to simple battery, domestic violence, and reckless conduct. Ms. Harrison, any prior nolo, please?
No, Your Honor, no nolo.
Okay, I'll accept a nolo contendere for simple battery and the reckless conduct. Ms. Helen, are we good?
Yes, Judge.
All right. Mr. Johnson, do you understand that if you choose to do so, you can enter a plea of nolo contendere, or what we call no contest, to the charges of simple battery, domestic violence, and reckless conduct? The charge of cruelty in the third degree is going to be dismissed as a matter of law. Do you understand, sir?
Yes, ma'am.
But it doesn't mitigate what you will be required to do if you decide to plead no contest to these charges. So in that light, Mr. Johnson, have I placed you under oath? Do you solemnly? Okay. Mr. Johnson, are you under the influence of any kind of medication or alcoholic beverages?
No, Judge.
And do you understand what's been happening so far?
Yes, Judge.
Repeat, please. I can't understand.
Yes, Judge.
Are you satisfied with the representation of your attorney, Patrice Helen?
Yes, Judge.
And do you understand that if you decide to plead nolo contendere to the two charges on this case, that you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to have the assistance of counsel to confront your accuser, challenge the state's case and its evidence, to argue your case before the judge and jury, and have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to waive these rights?
Yes, Judge.
How do you plead to one count of simple battery, domestic violence, and one count of reckless conduct?
Nolo.
I accept your plea. Your sentence for both charges will run concurrent, and it is 12 months to serve 60 days. Credit for time served, 12 days. You will have 18 more days to serve at the Fulton County Jail. Once you've completed those 18 days, you'll be released, and you'll have to report to probation within 48 hours of being released. While on probation, you shall stay away from the entire apartment complex referred to as 440 Thomasville Boulevard in Atlanta, Georgia, and you shall have no contact with Wylisha Cosby, which means staying 200 yards away from her and not communicating with her in any way, form, or manner, including a third party, with the exception of the transfer of children. But you cannot communicate with her through social media, through a phone, computer, or in person. Do you understand?
Yes, Judge.
If she initiates contact with you, you're required by law to make sure that you do not continue with that contact. No illegal drugs, no alcoholic beverages, no weapons, and no firearms. You will be subject to random screens by your probation officer. Within 60 days of being released, you shall enroll in a domestic violence intervention program and complete that program at your expense. Your probation fees shall be waived up to and including July 30th, 2022. After that, your probation, you still report to probation, and you will start paying probation fees from August 1st, 2022 onwards. You are to complete 80, that's 80 hours of voluntary community service, and you are permitted to have visitation with LJ through third-party transfer. Understood?
Yes, Judge.
That concludes this case. Thank
Thank
you.
you, Judge.
Next case, please.
Position 4, Mr. Cogdill.
We have Mr. Eric Wayne Cogdill, 21 CR 004421J, accused of loitering on March 30th, 2020. And this is going to be an arraignment.
Judge, no, this is position 4.
Oh, excuse me, 4. This is going to be a non-negotiated plea. Okay.
And Judge, actually, it was only whether it be probation, but I think we've clarified through a couple cases that there is no probation since it's valid suspended being offered there. So this is a negotiated plea, Judge.
All right, thank you. Mr. Cogdill, you've been advised of your right to remain silent. Your attorney is Ms. Helen, and for purposes of this plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Ms. Webb, what's the recommendation?
Yes, Your Honor. In this case, the state is recommending 12 months to serve 30 days, credit for time served, balance suspended, a stay away from the 123 Marietta Street. That is the LAZ or Lay's parking lot.
Laz.
Last, thank you.
Understood. Thank you. Ms. Helen, do you stipulate to the factual basis, venue, and ID?
Yes, Judge.
Thank you. Mr. Cogdill, are you under the influence of any kind of medication or alcoholic beverages?
No, ma'am.
Are you satisfied with the representation of your attorney?
Yes, ma'am.
And is anyone forcing you to take this plea today?
No, ma'am.
If you decide to continue with this plea, you would have to waive your constitutional right to go back to court, to have a trial before a judge or a jury, have the assistance of counsel to confront your accuser, examine witnesses, challenge the state's case and evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
How do you plead to one count of loitering?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served, which means, has he completed his time at the jail? This is
Yes, Judge.
Mr.
It's
Cogdill.
108 days. Yep.
All right. So you have completed your time at the jail. You will be released within 24 hours. You balance suspended, which means that you do not have to be on probation and your time at jail is completed. You are to stay away from the LAZ parking lot located at 123 Marietta Street in Atlanta, Georgia. If you are seen anywhere near that parking lot, on the curb, the sidewalk, or across the street, you could be arrested again for criminal trespass. Do you understand? Do you understand, sir?
Yes, ma'am.
All right, that concludes this case.
Thank you, Judge.
Last case, Judge, is position 17, Mr. Palmer. Palmer.
Eric Palmer is accused of simple battery in 21 CR 008-011B. Mr. Palmer, you've been advised of your right to remain silent, and your attorney is going to be Mr. Finley. I understand this is going to be a non-negotiated plea. Is that correct?
Yes, that is correct, Your Honor.
All right. Mr. Palmer, you've been, I'm going to first hear from the prosecution, and then I will hear from your attorney, after which I will let you know how we're going to proceed. Ms. Mitchell?
Yes, Your Honor. The plea recommendation from the state is 12 months to serve, 60 days confinement, credit for time served, 15 days, balance probated, no further contact with victim, Dimery, Dimery, Bell, stay away from 1122 Perimeter Center West, Atlanta, and 8-week anger management course, and no alcohol, drugs, and weapons.
It's the Marta incident, right?
Yes, Your Honor.
Anything else, Ms. Mitchell?
No, Your Honor.
Mr. Finley?
Yes, Your Honor. We are asking for a reduction from 60 days confinement to 45 days confinement. Additionally, Judge, we are asking for probation fees to be waived, as leading up to his arrest, Mr. Palmer was homeless. He has no money, and I'd hope that that money could go towards supporting and caring for himself. So just the fees to be waived, Your Honor.
All right. I'm familiar with this case. I'm going to accept the state's recommendation of 60 days. Credit for time served 15 days, which means he has 45 more, excuse me, he has, is it 30 more days, 15 more days? Ms.
Yeah,
Mitchell, how many more days? Ms. Mitchell, how many more days would he have to serve at the jail?
I'm sorry, 60 days confinement. He has 15 days.
15
right
days left, okay. So he would have 15 more days to serve at the Fulton County Jail. after which he will be placed on probation. He will report to probation every month. I will waive probation fees, all probation fees, and he needs to stay away from all MARTA property as long as there is an active MARTA suspension against him. Mr. Palmer, do you still want to proceed with the plea?
Guilty.
You would need to complete 15 more days at the Fulton County Jail. You cannot have any contact with Dimary Bell, and you have to stay away from all MARTA property as long as there is an active MARTA suspension against you. Do you still want to proceed?
Yes, ma'am.
Your
Mr.
Honor,
Finley?
I'm sorry to interrupt, but just for clarification, is he serving, did it change to 30 days confinement with credit for time served 15 days or 40?
No, I'm going with your recommendation, 12 months, 60 days to serve, credit for time served 15 days.
Okay.
So I don't do the math, so I count on,
You're right, Judge, 15 additional days, 60 days, half that, that's 30, so.
I got you, Your Honor. Thank you. My apologies.
all right. So just to clarify, Mr. Finley, shall we proceed?
Yes, Your Honor.
All right. And do you stipulate to venue and ID, Mr. Finley?
Yes, I do, Judge.
Thank you. Mr. Palmer, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Do you have any questions about the sentence that you would receive if I accept your plea?
Yes, ma'am. Yes.
Put your hand down. Do you have any questions about the sentence I'll impose if your plea proceeds?
I don't have any questions, ma'am. I just,
All right.
I learned from I'm sorry for what I done. I won't do no more. I learned my lesson, and
Well, you'll have to report to probation every month. If you don't report to probation, you'll be arrested. So I hope that would be the lesson you learn. Mr. Palmer? Hello, Mr. Palmer, you need to sit up straight so I can see you. You'll have to report to probation. You don't have to pay probation fees, but you have to check in at least once a month.
Okay.
And if you don't, you will be arrested.
Yes, ma'am.
All right, put your hands down. Mr. Palmer, are you under the influence of any kind of medication or drugs?
Under the influence?
Yes. Have you consumed any medication or alcoholic beverages? Yes or no?
No, ma'am.
Have you understood the proceedings so far?
Yes.
Are you satisfied with your attorney, Mr. Finley?
Yes.
And if you decide to proceed with this plea, you would have to give up your constitutional right to go back to court to have a trial before a judge or a jury. Are you prepared to give up that right?
I plead guilty.
If you plead guilty, you would have to give up your right to go back to court to have a trial before a judge or a jury. Are you prepared to give up that constitutional right?
Mr. Palmer, these are those questions that I went over, reviewed with you yesterday. Do you remember? So the judge is just saying, through your guilty plea, you're just giving up your right to a trial by jury, which is what we talked about yesterday.
Mr. Palmer, do you understand the question?
You want to say yes or no?
You need to answer me as to whether you're prepared to give up your right. All right.
Yeah.
Okay, Mr. Palmer is not prepared to go forward with this plea. Mr. Finley, I'll be glad to arraign the case and schedule it for a trial.
Okay. Yes,
Right.
Your Honor.
Mr. Palmer, your case is going to be scheduled for a trial. Would you like to file a waiver of arraignment, Mr. Finley, or would you like me to arraign him?
If we could arraign him, Judge.
All right. Mr. Palmer, your case is going to be, Mr. Palmer, please raise your head so I can see that you understand.
Palmer, she's talking.
Mr. Palmer,
She's talking to you.
if you could lean up if you don't mind, and please respond verbally to the judge.
Do you understand what she's saying?
All right.
Mr. Palmer,
He's not understanding, Judge.
Yeah, Judge, could it be possible that we could have a breakout room? Since he's the
Sure.
only person in there, so Mr. Finling can just talk to him and I can join too.
Definitely.
Yes,
Well, let Mr. All right, that's
Okay.
fine. Whoever wants to talk to him. Mr. Findling and courtroom 2, if you could please go into Miss Lewis, if you could place courtroom 2 and Mr. Findling in a breakout room, please.
Thank you.
Do I have any other cases, any other location?
No, that's it, Judge.
All right. Okay, I'll be back with you, courtroom 2, as soon as Mr. Findling has spoken to his client. Miss Helen, if you could remain, I just need to go down the calendar. With regards to my add-on calendar, let me see, it's not 11 o'clock. Yes, I have a DV bench reset for Babak Nakui. So we'll address that shortly. Add-on calendar, physician Jordan Burnett. Was he released?
Judge, so his attorney did send a message yesterday.
Yeah.
I'll forward you the email, but he was asking for the case to be reset.
Okay,
It was something
we can
about a program, so I'll
yeah.
forward you the email.
Okay, we're gonna reset it to January 20th.
Yes, Your Honor. Did you say Burdett?
Yes, Burnett. This was the special reset from Tuesday's C calendar.
Yes, Your Honor. He had a 10-13 hold.
Yeah, okay. So this one's reset to January 20th. I'm specifically resetting it to the SAP next Thursday because I'm on that SAP calendar, so I'll be familiar with the case. Mr. Findling, are you ready to proceed with Mr. Palmer?
Your Honor, if we could reset Mr. Palmer to Tuesday, I believe he walked away as well.
All right, we're going to reset Mr. Palmer to January 18, and that was position 18. Yeah.
All right,
All right. Okay, folks, we're going to go down the calendar. Mr. Findling, January 18th is full up. It has to be January 20th.
January 20th, okay.
Yeah, all right.
Thank you, Judge.
Okay, I'm just going to go down the calendar, please. I'm on the add-on calendar. Burnett is forward reset to January 20th. Position 2 and 3 on the add-on, excuse me, position 2 was a plea. Position 3, Martinez Gunetta is a reset, and Miss Middlebrooks, is it reset to the 20th or the 18th? The 20th. I know I said 18, but apparently it's full up, so we can't squeeze it anymore into that date. So it's reset to January 20th, 2022. We'll need a Spanish interpreter for that case. For the regular calendar, position 1, Bannister. Is that represented by Miss Helen?
Yes, Judge.
Are you filing a waiver of arraignment?
Yes, Judge.
All right. Please do so. Has it been filed? I don't know.
No, I'm sending that today to Ms. Middlebrooks.
All right, thank you. Waiver arraignment to be filed. So it'll be further notice for trial. Position 2 was a plea. That was Johnny Barnes. Position 3, Malachi Bullock.
That was actually handled on the 1/11 Tuesday SAP, and the disposition was that it was a bond hearing and it was arraigned, Judge.
All right, so this is further notice for trial. Thank you. Position 4 was a plea. Position 5, Michael Davila. It's a medical reset. I'm assuming it's already been reset to January 18, Ms. Middlebrooks? No, it's to 20. It'll be a medical reset to January 20th.
Okay.
Position number 6, Hagan. Any announcements?
Well, Judge, I was informed she was a medical reset through the jail. I don't have a date.
January
Okay.
20th, medical reset. Physician 7, Hawkins is released. Physician 8 is a plea, Johnson. Physician 9, Jones was a plea. Physician 10, Lloyd was arraigned and further notice for trial. Physician 11, Anthony Lyons is released. Physician 12, Lamberto Marcial is going to be reset to January 20th, and we need a Spanish interpreter for that. Physician 13 and 14, Antoine Martin and Christelle Mays, are going to be a medical reset to January 20th, 2022. Physician 15 was a plea. Physician 16 is a MH reset to February 8th, 2022. Physician 17 was a plea. Oh, excuse me, that's reset to January 20th, not a plea.
Which one, Judge, 17?
That was Palmer. It's reset to January 20th, the last one we addressed. Physician 18 is Orlando Poole, and that was arraigned and further noticed. Mr. Finding, was that arraigned or did we reset it? Orlando
Your
Poole.
Honor, number 18, we modified that to was not guilty to a $3,500 surety bond.
Oh, okay. So it has been arraigned and further notice for trial?
Yes, Your Honor. Yeah, not guilty, and then the $3,500 surety bond. Yes, Judge.
Okay, thank you. Physician 19, Prather, was released. Physician 20 was arraigned and further notice for trial, bond modified. Physician 21 was a plea. Physician 22 was a plea.
Your Honor, just for clarification on position number 1, Mr. Bannister, was that a reset as well?
No, Miss Helen is going to file a written waiver of arraignment. So the case is going to be further notice for trial.
Thank you.
All right, folks, I'm going to remain on the Zoom. I have a 11 a.m. Babak Nikui for a motion to set aside a bench warrant. Appears to be self-represented.
No, Judge, he's represented through our office, but there's an attorney who's entered a entry of appearance. I believe her name is Emily, and she will be appearing for position 1 at 11.
Okay, did the PD's office want to stand? I'm assuming y'all have sent the Zoom link to the new attorney?
Yes.
Okay, all right. Okay, folks, thank you very much. I'll be back at 11 a.m. I'll be in recess till then. Thank you, everyone. Be safe. Thank you.
Thank you.
Ms. Bronstein?
Yes, Judge.
Good morning.
Good morning.
All right. Are you with the PD's office?
Yes, I am going to be representing Mr. Nikui for the 11 a.m. bench warrant.
Is he here by any chance?
I told him to log on a little bit early. I will email him. I'm
Okay.
also expecting the complaining witness, his son, to be logging in too.
All right. If they want to get started, just have them log in. I don't know. I'm assuming it's going to be either Miss Webb or Mr. Hopkins, who will be, Miss Mitchell will be the prosecutor. So The only folks we're waiting for is the defendant and any witness he may have.
Okay, I will email both him and the complaining witness right now.
Okay, just appear when they show up, okay?
Thank you.
Thank you. All right. Good morning. This is Judge Jesse Law, and we are addressing our DB bench warrant calendar. Ms. Bronstein, I see Mr. Babak Nakui. I hope I'm not butchering the name, but I do see him present along with a witness, Mr. Koran Nakui. And Ms. Mitchell is going to be our prosecutor from the Fulton County Solicitor General's office. Ms. Bronstein, any objection to starting 2 minutes before the scheduled time?
No, Your Honor, we're prepared to start.
All right. This is case number 19 CR 006229F, State versus Babak Nakui, accused of battery, domestic violence, disorderly conduct, and public drunk, allegedly from a July 28, 2019 incident, pursuant to two failures to appear at two separate calendars before the Honorable Judge Eric Richardson. A bench warrant was issued for Mr. Nakui's arrest. Mr. Nakui has apparently filed a request to set aside the bench warrant. So we will proceed accordingly. Mr. Babak, you have a right to remain silent. Anything you say in open court, even this recorded proceeding, your statements can and will be used against you. You have a right to an attorney, and at the present time, Ms. Emily Bronstein from the Fulton County Public Defender's Office is representing you and has filed the appropriate entry of appearance. Yes, Ms. Bronstein.
Yes, Your Honor. Do you want me to proceed with my argument now? Sorry, I've just never done one of these calendars.
Yes, please do so. Just articulate the reasons why I should set aside the bench warrant, and Ms. Mitchell, and if you want your client to testify, that's up to you. If you want the witness to testify in support of your motion, that's again up to you.
Okay.
And then Ms. Mitchell will counter with cross-examination and her argument.
Okay. Thank you, Judge. Mr. Nakui reached out to my office. He has actually been stuck in Iran since October 2019 and has been unable to return to the US. He went to visit family and did not foresee being stuck in the country. And he has been actively working on the issue to try to get back. However, he didn't receive the court notices. He reached out to my office. It took him a while to figure out who to reach out to. He and his son, the complaining witness in the case, have been trying to reach out to the appropriate people once they figured out that this was an issue. It just came to my attention. I now have good contact information for him. He's very responsive and easy for me to get a hold of. Due to the fact he's on a different continent, we have been corresponding over email. This case occurred, as the court said, in July 2019, and his son, Mr. Arraign Nakui, is the complaining witness, and he is now an adult. He told me that he was almost 20. I've spoken with him, and he told me that he does not want his father to go to jail once the bench warrant lifted, and he does want contact with his father. That's one thing that I wanted to know if I could address. Sorry, that's my dog.
Okay.
Okay, sorry. And he is here today to support his father. And he'd be happy to answer any questions the court or state has for him. As believe there might be a no contact order for the bond order. So that is something else I wanted to address with the court to see if we could change that to no violent contact, as well as requesting the bench warrant to be set aside. At this time, I would ask if Mr. Arraign Nakui if I could question him.
Sure. Mr. Arraign, if you please unmute your screen.
I'm unmuted if you guys can hear me. Am I good to go?
Are you driving?
No, I'm not driving. I'm in my car. I'm in my
Okay,
it's the most quiet place I can be.
Please raise
at.
your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I swear.
And what's your name?
Arraign Nakui.
And how are you related to Mr. Babak Nakui?
That's my father.
All right. Are you the alleged victim in this particular case?
Yes, ma'am.
Are there any other alleged victims?
No, ma'am.
All right. Ms. Bronstein, you may proceed with your examination.
Thank you. Mr. Nakui, are you afraid of your father?
No, I'm not.
Do you want him to go to jail on this case?
No, ma'am.
Do you want contact with him?
Yes, I do.
And would you like to see the bench warrant lifted in this case?
Yes, ma'am.
Okay. Those are all the questions I have at this time. I'm subject to redirect.
Ms. Mitchell?
Yes, Your Honor. Good morning, Mr. Arraign Nakui. I just have a few questions based on the incident report. Isn't it true that you told the officer that your father attempted to rip your shirt off?
See, as I go back and think about it more, so much happened that night that I wasn't sure. And I really do think that it was a misconception by me of saying that it might have hit me or he might have hit me. But I think that when we were there, and I know he grabbed my shirt just to get my head straight to say, you need to come home, because I wasn't very much in the wrong. I was spending time where I didn't need to, and I was a young kid. And now that I look back at it now, my dad was trying to be a good father and get me out of situations that I wasn't supposed to be in and stuff like that.
Okay, but isn't it true that you told the police officers that he punched you?
No, I did not say he punched me.
Okay,
And
isn't it
Your
true?
Honor, I would object actually to this line of questioning. This appears to go to the case itself and not the issue of the bench warrant.
Overruled. Please continue.
Okay. Isn't it true that your father chased you through your girlfriend's house? Your girlfriend's mother's house?
Well, they said, the people that were there, my girlfriend's family, they said that he chased me, but he was walking around the house trying to get me to listen to him and actually not, go back and forth with him like I was being a little kid and yelling and trying to overwrite his way of talking to me. And that's why he got heated and started yelling at me back, because I was the one that was yelling.
Okay. And isn't it also true that you told officers that you didn't feel comfortable going with him because he appeared to have been drinking?
That night, I didn't feel to be comfortable going home at all because of the yelling and stuff that had happened that night. And I didn't feel comfortable by myself putting myself in the situation and my dad in the situation of starting another argument that same night, because we already just got finished with one. Anything could happen if we would have spent a day or 2 days without each other. And then 2 days later, we texted and we resolved everything when we were all both calmed down. And we both know we were in the wrong.
Nothing further, Your Honor.
Ms. Bronstein, a redirect?
Just to reiterate, Mr. Nakui, this occurred on July 2019.
Yes, ma'am.
All right. That's the only redirect I have.
Mr. Oran, where do you live right now? Do you live still at the Courtyard Terrace?
No, I used to live there. And then I moved to Duluth in Georgia. Right now, I'm staying in Gainesville. I recently moved here about a couple days ago. I had a lot of situations happen in my old apartment that I had to move out really fast.
All right. And what is 4645 Ballet Court?
That was our old house that me and my family used to live together at.
Why do you call it an old house?
Because we used to live there, I think 3-4 years ago, and that's the house I grew up at, basically. And then I call it my old house because it's basically a house. It's not an apartment.
Who occupies it now?
The old tenant, I'm pretty sure. I think it's still vacant.
Oh, okay. So when was it vacated?
I think last year, around there, I think. I'm not too sure.
That would be 2020?
Yes, ma'am.
When did your father travel to Iran?
My father, we weren't really in contact when he traveled. He told me when he got there, I can't really remember when it was, but he told me that when we first got in contact, he was trying to come back and his passport was taken away. And I was trying to help him get an attorney here or figure out someone that can give him a few pointers of how to get his passport back. And we've been going back and forth to try to figure out the situation for months now.
All right. Thank you. Ms. Bronstein, anything else?
No, Your Honor. I just like to renew my request that the court set aside the bench warrant, and I just want to make sure that the bond order specifies no violent contact.
All right. Ms. Mitchell?
Yes, Your Honor. The state's concern here is defendant being a flight risk because of the failure to appear. But as stated and disclosed, he was stuck in Iran. So we are understanding of that. As long as he's not a flight risk, we would not oppose the bench warrant being set aside.
Well,
I'm sorry, Judge. I would like to reiterate that since I
don't know whether he's a flight risk because he's halfway across the planet, as far as I'm concerned. If that location is correct, unless you want him to pan his camera outside, if you can recognize downtown Tehran, I mean, that's different.
Your Honor, my apologies.
I really don't know if he's a flight risk. What I do know is that he made bond on July 29, 2019 to the tune of $7,000 surety bond, and he has not bothered to update the court with his change of address if he has vacated the premises or the premises were vacated, or to inform the court that he's not available and has left the country. But he has not bothered to inform the court that he had a change of address. And Judge Richardson has repeatedly been trying to reach him twice, and he did not show up in court when summoned based on the address that we have on file. So the question I have is, why should I not issue a bench warrant so that the minute he lands in the United States, we will have him extradited from his port of entry to Atlanta, Georgia?
And Your Honor, I can address that. Mr. Nikui, he has been trying to get in contact with a lot of people, and it took quite a while for me to get involved. He sent an email to the chief assistant at my office detailing all of the people that he has been trying to get in contact with. And there's also the issue of mail from the US getting to another country. However, he is very responsive to my emails. As soon as I got involved, he responds right away. I believe he would absolutely show up to any court date via Zoom. And I would file the appropriate motions with Judge Richardson if he is still out of the country to do the court dates over Zoom. And that when he is returned, I do not believe that he would skip court.
All right. Have you filed a waiver of arraignment?
Not yet. I filed the entry and was going to come here before I filed any additional motions.
Are you prepared to have your client arraign are you prepared to move forward with arraignment? And then I'm going to forward the case to Judge Richardson. And
yes, Your Honor.
And when do you anticipate your client coming back to the country?
I think my understanding is they are shooting for April 2022, but I don't know if that is set in stone yet. But yes, we would at this point waive arraignment and enter a plea of not guilty.
All right. And what's a good address to reach him?
I have an address for him in Iran. So
Miss Katrina Lewis, do we send notices to Iran? I'm not being facetious. I really don't know. So
if not for now, as the attorney of record, I can accept court notices for him, and I will take responsibility to deliver him the information.
All right. So next question, are you going to file the waiver of arraignment, or do I arraign the case today?
Whichever Your Honor is more comfortable with, we can go ahead and arraign the case today.
All right. Mr. Nikui, please unmute your screen. Mr. Babak Nikui.
Yes, ma'am.
All right. First of all, I'm going to set aside the bench warrant, and your your $7,000 surety bond is reinstated. So Ms. Bronstein, please put that information in the proposed order. The bench warrant issued you on your file, Mr. Nikui, I'm going to address you as Mr. Nikui just to distinguish you from Iran, is that you have two failures to appear on this particular case because of your neglect in updating the court with your change of address or change of location. That doesn't reflect well on your record. So please keep in mind the fact that I'm setting aside a bench warrant doesn't mean that I excuse your neglect. You understand, sir?
Yes, I do.
Your attorney, Ms. Bronstein, is going to update the court with your contact information. So Ms. Bronstein, if you either have a good mailing address or if you want the clerk's office to send notices to you personally at your office, you need to inform the clerk's office because we still have his Alpharetta address as his current address. And that's no longer a current address. We need to update it with a current mailing address.
For now, we can use my address.
All right. So Ms. Katrina Lewis, Ms. Middlebrooks, we're going to have to update Mr. Nakui's address with the address provided by Ms. Bronstein in her entry of appearance. Yes, Mr. Babak, once you come back to the United States, you must come back to the clerk's office at 160 Prior Street in Suite J150 and update the clerk with your current mailing address. That's required by law.
Will do.
And also a condition of your bond as well. Failure to update your address is a violation of your bond conditions. I'm going to arraign your case, which means that upon your entry of a not guilty plea, your case will be scheduled for trial before the Honorable Judge Eric Richardson. Your attorney will need to notify the judge that you are back in the country and that you're prepared to go forward with trial. The fact that Mr. Oran wants to recant or indicate that he's not inclined to pursue the charges has no bearing on the case. The decision to pursue prosecution is entirely with the prosecutor's office and not with the alleged victim. So, Ms. Bronstein, do you waive a reading of the accusations?
Yes, Your Honor, we'll waive a reading of an accusation and enter a plea of not guilty.
All right. So, Mr. Babak Nakui, you're accused of battery, domestic violence, disorderly conduct, and public drunkenness from a July 28, 2019 incident. These are 3 misdemeanor charges which are still active and pending against you. With regards to these charges, upon your entry of a not guilty plea, the case will be scheduled for trial before Judge Richardson. At the time of the trial, the prosecution has the complete burden to prove the charges against you beyond a reasonable doubt. If the state prevails in carrying its burden of proof and overcoming your legal presumption of innocence, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
I understand, Your Honor.
Mr. Nakui, do you plead not guilty at this time?
I'm not guilty.
Your case has been arraigned and is further notice for trial before Judge Richardson. Just FYI, a bench warrant that is issued and off record right now does pop up with the State Department and all customs in any port of entry in the United States. So if we have that order setting aside the bench warrant, hopefully that will be updated with the State Department and all ports of entry. People don't believe me until their clients actually at a port of entry are facing the border control, and they do tell them it's right there on the screen. Okay. Ms. Bronstein, once you get a stamped file order indicating that the bench warrant is set aside, please make sure that you get a certified copy from the clerk's office to email to Mr. Babak in Iran so that he can use that as part of his entry documents. We certainly don't want him held up in wherever he happens to enter into the country.
Yes, Your Honor. So for the order set aside, should I write one and email it to your office, or how would I?
Email it to Ms. Katalia Middlebrooks, and she will put her email in the chat.
Okay.
All I'm saying is that you need to get a certified copy of that order from the clerk's office, so you can email that copy to Mr. Babak in Iran, and he needs to make sure he hangs on to it along with his passport or whatever documents he plans to use to enter back into the United States.
Thank you, Judge. I was definitely planning on doing that.
All right, certified copy. I'm telling you, State and Common, they don't fool around.
Okay, certified copy. Thank you. And I will get that to Ms. Middlebrook shortly.
All right. Anything else, Ms. Mitchell?
Oh, sorry, one more
Ms.
thing.
Summers.
About the, I just wanted to make sure, would we be able to, for the bond order, do a, just make sure that it's a no violent contact? I looked in Odyssey and on the front page, I just saw that he bonded out. I didn't.
How old is Oran now?
I'm 18 years old.
Oh, 18?
Yes, ma'am. Well, just
Okay.
turned 19. Yeah, a couple of days ago.
All right. Ms. Mitchell, any objection to a no further violent contact?
No, Your Honor.
All right, Ms. Bronstein, in the proposed order, number 1, set aside the bench warrant. Number 2, reinstate the surety bond. Number 3, amend it to no further violent contact with Oran Nakuri. All other conditions remain the same, including making sure that the clerk's office has a current mailing address for Mr. Babak Nakuri.
Your Honor, this is Albert Hopkins. I actually just sent a message to ASG Mitchell about the contact provision. We do object to there being contact.
All right, why don't you chime in, Mr. Hopkins, and tell me, I'll reconsider my decision if I find grounds for it.
Your Honor, Ms. Mitchell knows the facts. I'm going to leave that to her, but I was just wanted to pause for a second so she can make that objection clear on the record.
All right, Ms. Mitchell?
Okay. So the facts of the case.
Yeah, I've read the warrants in this particular case. So this happened 2
Okay, well,
years.
I'm just gonna do a brief synopsis of the incident
Okay.
report. Officers responded to the address 108 Courtyard Terrace, Roswell, Georgia, at approximately 1 a.m. Upon arrival, officers came upon the defendant yelling loudly. The caller, Corinne Burgess, stated that she was asleep when she heard yelling coming from downstairs. That's Mr. Oren's girlfriend's mother. It's her home. The defendant entered her home without permission for the purpose of taking his son, who was a minor at the time, who had permission from the mother to be there, back to defendant's residence. Ms. Burgess stated that the defendant left the residence as soon as she told him that he was not welcome. Her daughter, who was a minor at the time, IB, state that she and her boyfriend, Mr. Oren, were watching a movie when they heard the doorbell ring. Mr. Oren went to the door and discovered it was his father, the defendant, and that he appeared to be heavily intoxicated. The defendant stated that he wanted Mr. Oren to return home with him. IB stated that the defendant entered the residence and chased Mr. Oren around the couch before grabbing his backpack and moving toward the door. She stated that the two were on the front porch of the residence when she witnessed defendant punching Mr. Oren in the neck and chest area. Mr. Oren stated to officers that his father attempted to rip his shirt off and chase him through the house before tussling with him. The defendant struck him in the chest with the heel of his palm, and that he pushed defendant's arm away. Officers observed visible marks on Mr. Oren's collarbone area. Mr. Oren stated that he didn't feel comfortable going with his father as it appeared that he'd been drinking. Officers also smelled that the defendant had a strong alcohol odor. His eyes were glassy and red. He was unsteady on his feet, and he was slurring his words badly. So that concludes the
And all right, so that synopsis, which is a complete recitation of the warrant. So we've already heard from Mr. Oran. We've heard that I don't have a indication that he's been arrested since this incident. And other than his failure to update his address and leaving country without letting us know, what other reasons should I address in order to amend it back to no further contact?
Your Honor, I just state on this. I mean, we have absolutely no contact or to my knowledge, any type of system update or syncing with Iranian criminal information systems. We don't know what his history has been for the past 2 years, that he's completely absconded from the United States, and there's duties to this court to go ahead and update them as to his address in a violent case that has involved apparently, if this was 2 years ago and the victim is 19 now, he was 17 at the time.
Yes,
This is also a child. So that is very concerning to the state. And honestly, right now, he's outside of our reach. So, if he comes into the borders, what's to go ahead and say that he comes to court and goes ahead and handles that? With him not being here today, Your Honor, the state is going to maintain that we don't believe that at this time he's demonstrated that he will follow the court's instructions, not prevent any type of influencing or anything regarding the witnesses or the victim, as the victim has now apparently today walked back or tried to clarify his statements that he made previously and at the time of the incident to the officers, showing there's possibility from influencing witnesses. So that's why we maintain, Your Honor, that we object to the set aside and we wish him to have no contact with the victim.
The Solicitor General's office has insight to tap into the Iranian criminal GCIC system. I'm sure there are a lot of important people who want to talk to you, Mr. Hopkins. But in the meantime, you have Iran on the Zoom. If you want to ask him questions.
Oh, no, I'm saying we don't have access to that. So I have absolutely no idea if while he's been in Iran, he has been arrested for anything else. If he's been gone for 2 years there, for all I know,
I agree.
he wanted
I agree with that. But Ms. Bronstein, anything else to counter?
Your Honor, I would just like to reiterate that this case is a few years old, and Mr. Arraign Nakui stated on the record that he is not afraid of his father and does want contact with him. And I would ask the court to take that into consideration.
Mr. Arraign has spoken, and he's apparently older and wiser. I mean, look at that beard. He's got to be more sage-like at this time. But on the other hand, I've also admonished Mr. Babak Nakui with regards to his neglect and his failure to update the address and the consequences if he doesn't come back to the country and face these charges in a court of law. I mean, at some point, we have to treat them as adults. So at this point, at this juncture, I am very comfortable with my decision that once Mr. Babak Nakui comes back to the country and is enters the country legitimately, that he can have no further violent contact with Arraign Nakui. That means no physical altercations and no verbal altercations. Of course, if there is such an altercation and the police get involved again, the person that is going to suffer the most is Mr. Babak, because he'll be back in jail and possibly facing a felony charge of aggravated stalking for violation of a court order. So, Ms. Bronstein, go ahead and submit your proposed order. I don't know what else to tell everyone, but hopefully everyone will learn to play nice, and we will see Mr. Babak in court hopefully in the future. Thank you, Mr. Hopkins.
The state is going to request that we have a date that the defendant is coming back in, and that be put into the order that he report to the court, as well as the Solicitor General's office and counsel whenever he arrives within 48 hours.
Okay. Ms. Bronstein, you mentioned he'll be back by April.
We believe so. He's not absconded willfully. He's being he's been trying to get back to the U.S. And is currently being held in Iran, and there is an issue with the passport that they are trying to deal with.
He has a return date of June 1st, 2022. And if there are reasons why he cannot return by June 1st, 2022, he needs to email you documentation to show what is hindering him from traveling.
Should I include that in the order to return by
Yes.
June 1st, 2022? And if he does not, to make the court aware of the circumstances.
We need verifiable documents as to what's hindering him. And if the documents are in Farsi, he needs to provide the English translation.
Okay. So need documents showing why he has not been able to return to the US, including a translation.
Deadline June 1st. So underlay. He needs to get cracking now.
Okay.
Thank you, ladies and gentlemen. This concludes our court. We will see you at 2